Hi, I'm Giles Emery. I'm Vice President, Corporate Counsel for Mynd Property Management. I'm going to talk to you today about how to successfully evict a tenant. So my number one tip is to avoid it altogether. Probably a topic for a separate discussion. We can go through steps on how to best avoid or get yourself into the eviction protocol, but evictions are costly. You're going to have attorney's fees potentially, and they're just time consuming. Every day, again, costs you money as a property owner. So assuming you are in the unavoidable spot of you need to evict a tenant, I'm going to walk you through some steps you can take to speed along the process and have sort of the most efficient eviction possible, if that is possible. But again, time is money, so your goal is to get through start to finish as quickly as you can. And it starts with the initial notice. So your initial notice could be the tenant's notice to vacate, where they're giving you a notice to vacate at the end of their tenancy. It could be your 30 or 60 day notice to terminate at the end of their lease term. More than likely than not, it's a pay or quit for failure to pay rent. And this could be like a 3-day pay or quit or a 5-day, depending on which jurisdiction or state you're in. It could be a cure or quit for breach of some other covenant of the lease, something other than payment of rent. Or it could be cure for a non-curable defect. This would be something where they breached the lease, there's no cure available. Typically this would be like illegal activity, drug house, things like that, where you're just terminating the lease, there's no option to cure. So each of these notices, they're all sort of creatures of the statutes in the various jurisdictions. So you want to make sure that you have a statutory compliant notice, and it starts at the state level, and then certain cities, local jurisdictions have requirements for language they want to see in these notices. But you want to have a form that you are comfortable with that has all that language, it's been vetted, and then you're just faced with plugging in the right information. So once you've got your form, next step is you want to make sure you're including the names of every adult that occupies that property, assuming you have all those names. Typically these would be the people named on your lease. And then you're going to want to include the property address, but one of the most important pieces is the amount owed. You've got to get this right. And again, this is where local nuances come into play on what you can include in that dollar amount. So California, for example, you want to include only past due rent. You can't include any late fees. There's a separate argument about whether you should, but for purposes of getting through this efficiently, do not include late fees, and don't include any other charges that come up through your lease, penalty type fees, just the rent. And don't charge a penny more. It's got to be the exact amount or less. And then don't attach any notes to your notice. Don't take this as an opportunity to send a letter with the notice for something other than what's covered in your notice. Just serve the notice. That's your statutory. This is your prerequisite step to filing the eviction. It's the first step in the eviction process. You got to get this right. And I'll talk a little later about why this is the most important piece, in my opinion, and it's because of the delay. So if your notice is defective, it's going to be subject to attack sometime down the road. This could be 30 days later, 60 days, or it could be all the way at the end when you're at your trial, which could be, depending on the jurisdiction and the type of trial, you could be 90 days in and have your whole case thrown out because you've got a defective notice. You charged too much, you included a late fee in that amount. And have your case thrown out. Now you've got to start all over, and you've lost 60 days, you've lost 90 days, really costly mistake. And then once you've got your notice filled out, the next step is to serve it, which in every jurisdiction, the best method of service is personal delivery. That means you're physically handing the notice to your tenant. There are other methods that are perfectly available, fine, which is substituted service, where you can serve it on any adult that answers the door. It doesn't have to be the person you're trying to serve, but you leave it with the adult and then you follow up with a mailing. There's options to do, again, know your local laws, but posting it on the door and then doing a follow-up mailing as well. And then whoever is doing that service of the notice, you will want to have them fill out what's called a proof of service. This could be included in your notice, or most instances a separate sheet that they're filling out, just a proof of service that says, I, John Doe, served so-and-so at 123 Main Street on this date by personally handing a copy. And that gets attached to your notice with your eviction file. It's your prima facie evidence that you properly served that notice. So really important to include that with your notice when you come to filing your eviction paperwork. Once you've served your notice, you want to start gathering your documentation. Again, delay is costly, so as soon as your notice expires, and I'll use in most instances, you're going to be filing an eviction based on failure to pay rent. So in California and most jurisdictions, it's a 3-day period. You don't count the first day, you count 3 days, and then that's their window to cure, i.e. pay the amount that you're asking for on your notice. And if they don't pay by the 3rd day, then you can proceed to file your eviction paperwork. And that 3rd day, and again, jurisdictional nuances, but in California, for example, it can't land on a weekend or a holiday. If it does, you go the next business day, that's their last day to cure. But you want to have your case file or the documentation ready to send over to your preferred eviction counsel as soon as it expires, or even before it expires, so that they can start the process to vet the documentation, prepare the complaint. These complaints are easy for them to fill out in most instances. A good eviction firm should be able to prepare the complaint that same day. And then depending on the timing, courts have cutoff dates for timing, either file it that day or first thing the following morning. And again, you just start, each of these steps starts the clock for the next process. So if you can cut out a day here, a day there, 2 days along the way, it all adds up to getting your property back into a income producing state sooner than later. As part of the types of things, documentation you're going to want to send over or have ready, in most instances it's not complicated, just a copy of the lease. It's a copy of the notice you served with the proof of service I mentioned earlier. If it's a failure to pay rent, you're going to want to include the tenant ledger that shows the amounts owed and how you calculated the amounts that are on your notice. And if it's for breach of some other non-covenant, then you're going to want to include any information that's relevant to that breach, communications or documentation that shows what they failed to cure. Once the complaint has been filed, then your eviction counsel can start the process, or maybe it's somebody else, a process server, to actually serve the summons and complaint. So this is different than serving the notice. This is the actual complaint that have different statutory requirements. Every state's very specific on how a summons and complaint can be served. But again, in every jurisdiction, personal service is the best method. So in California, if you're able to serve the complaint personally, or your process server is, the defendant then, or your tenant, has 5 days to prepare and file their responsive pleading, which is typically an answer, and file that with the court within those 5 days. And if they fail to do so, you can take a default. So personal service, they get 5 days. These other methods that I mentioned with the notice, like substituted service, perfectly valid service, but it adds an additional 10 days for their time to respond. So now instead of 5 days, it's 15 days for them to respond to the court hearing. So that's an additional 10 days, which is meaningful. And then if you're unable to perfect substituted service, means you can't find anybody at the property, an adult anyway, to serve the papers, and you've made reasonable efforts to do it, you can typically go into court, ask for a court order allowing you to serve the summons and complaint by post and mail. But you've got to prove up to the court that you've made reasonable attempts to do these other methods before they'll give you an order allowing you to post the complaint to their door and do a mailing. So you lose a whole bunch of time going through that process. You got to get a court order. It takes time to schedule that, get approval from the court. Then you can go out to the posting, and then they've got this additional time on top of that. So really costly in terms of the delay. So wrap up point there is, if you've got information that will help your eviction counsel, the process server, be successful in a personal service, by all means include that with your package. So this would be, if you know when your defendants or your tenants are typically home, extremely helpful information. If you know where they work, even better. They can be served at work. Chances of somebody being at work and being able to be served is highly successful. Even physical descriptions. So any information that you think will help the process server be successful in that personal service, make sure you include that information. Time is valuable. Once the complaint's been served, then they're going to either, the tenants or your defendants in this case, can either do nothing, which is what we call an uncontested eviction, meaning the 5 days or whatever time period they had to respond to the complaint comes and goes and they don't file a response with the court, you can then take their default and proceed that way. That would be an uncontested case. In terms of efficiency, that's the best case scenario. What that'll allow you to do in California, for example, you can then go into, when the 5 days expires, assuming you perfected personal service, you can file a request for default and a request for entry of a judgment for possession only at the same time, and the clerk is allowed to enter that judgment right then and there, meaning you get a judgment right away for possession of the property that you can then take over to the sheriff and get in their queue to schedule the actual eviction or lockout. So when we say possession only, that means the judgment is just for possession of the home. You can't include money damages in that judgment if you want the clerk to enter it right then and there. You can go and pursue money damages later if you think it's worthwhile. That's a separate discussion. But if you have the opportunity to get a judgment for possession right then and there, by all means, that's the most important piece. Get this home back as soon as possible, get it renovated, and get it back leased out so it's producing income for you. If the other option is the tenant files a response, and that's what we call a contested eviction. That means they've actually, before the 5 days expires, or the 15, depending on how they were served, they've gone into court, they've filed their responsive pleading, which is typically an answer to the complaint, and then they may be represented by counsel at that time. And this is where, if they are represented by counsel, the first thing that counsel is likely to do is take a look at your notice and try to find a defect with your notice. And if they do find a defect or something they don't like, you included late fees, you did something along the way that potentially negated or was fatal to that notice, they have the opportunity to file a motion right then and there. That's just delay. You've got to now have a hearing on the motion, go through the statutory timeframes to do so before your eviction can proceed, and then you're either going to have the opportunity to cure before your eviction can proceed, or maybe even your case gets thrown out at that point, depending on the defect. So real important, nail that notice, get that right. It's not difficult to do, just have the right forms. And there's various other delays that counsel may take that hopefully you don't encounter. Filing motions, as I mentioned. They may propound discovery, which typically is just a delay tactic. They send you over formal requests for information, and you're on sort of a court schedule in terms of when you have to respond and when things move along. They could request a jury trial. A jury trial just delay things because it takes the court a lot longer to schedule a jury trial rather than the typical bench trial. Bench trial just means you're in front of the judge only. Judge is hearing your case. They can schedule those a lot quicker than having a jury. Jury trials are more expensive. It's usually a tactic that's used to put pressure on you to settle the case rather than going through the trial. And then worst case scenario, you've got a defendant that's filing unscrupulous bankruptcies, and that's usually just a delay tactic, and it's a harmful one because as soon as you file bankruptcy, your case comes to a screeching halt. There's a bankruptcy stay that goes into play. Now you got to go into federal bankruptcy court, entirely different court system, and get relief from the stay and approval to come back into state court and proceed with your eviction case. To wrap up, nail that notice, or I should take steps to avoid eviction altogether. That is your best case scenario. If you can get ahead of these things through communicating with your tenants, setting the right expectations, and avoid the eviction, by all means, that's usually the best path forward. But assuming you're not, make sure you've got the right notices, make sure they've been vetted, and have the requisite statutory language, and you understand the local nuances of what you can and can't include in those notices. Make sure you've got organized documentation that you're ready to get over to your eviction counsel in a timely manner that's going to give them the best chance to prepare the right complaint and move along as fast as possible. If they've got to come back to you for additional information, that adds a day or two here of back and forth. Have that stuff ready to go. And then lastly, hire the right eviction firm. A good firm makes a difference in terms of marching your eviction through the whole process in a timely manner. And a good property management company is going to help you nail all of those things. So if you have any questions, feel free to reach out to Mynd, reach out to me, but Hopefully you don't find yourself in eviction. If you do, there's steps you can take to make it as painless as possible.